Every year, thousands of construction workers are seriously injured in New York City. Construction workers find themselves confronted by dangerous, unsafe work conditions on a daily basis. New York State has enacted laws and regulations to protect all workers. However, these laws and regulations can be very difficult for the injured worker to navigate without the help of experienced construction lawyers. In this insider-exclusive network TV special, Traumatic Brain Injuries, our news team visits with Andy Siegel and Siegel Coonerty, partners at the Siegel and Coonerty Law firm, to learn how they successfully represented their client in a construction accident resulting in traumatic brain injuries to get him a record $12 million verdict. They both have earned reputations as unyielding trial lawyers who repeatedly represent individuals and families against big companies and the Goliaths of the world, and repeatedly win. They have earned the highest respect from citizens and lawyers alike as one of the best labor law and traumatic brain injury law firm in New York. They built a substantial reputation by consistently winning cases other law firms have turned down, and their amazing courtroom skills and headline-grabbing success rate continue to provide their clients with the results they need and the results they deserve. This is the Insider Exclusive, live from New York. It is my great pleasure to introduce Siegel Coonerty and Andy Siegel to the show. Welcome to the show, guys.
Thank you.
Andy, tell our audience exactly what type of law your law firm practices.
We have a particular focus on representing survivors of traumatic brain injury. However, we have a diverse practice where we represent people with injuries that are other than the brain.
And I understand that your specialty, Sean, is labor law, isn't it?
That's correct. In the sense of construction accidents that cause a construction worker to have a severe injury.
Yeah, here in this city, and you represent people all over the state, I would imagine, right? But here in this city, there's a lot of accidents, right?
There are.
Everywhere we look, when we were driving here, we saw buildings under construction, and it's amazing. Do you ever represent passerbys that get injured by things that are falling from buildings?
As a matter of fact, we have, and there is actually a specific section within not the labor law, but one of the codes that the labor law is based on, the industrial code for the state of New York, that actually speaks about that actual incident occurring. And we have had that, but it's infrequent. More often, we've had a construction worker that potentially was not involved in that aspect of the construction, but just happened to be walking to their truck or something of that nature. One of which we had, this gentleman was just walking to his truck and the sidewalk shed collapsed and fell down on him like an accordion.
We're here today to talk about another one of your clients that you did a spectacular job for. So Sean, tell our audience a little bit about the facts of this case.
Thank you, Steve. Diego was a Portuguese concrete worker, meaning that he and many like him are the people that build New York City. They have to put together forms that concrete then gets poured into, the concrete cures, and then they keep going up another level and another level. In this particular case, he was on the roof of the time, which at that point was the 4th floor. And below him was the 2nd floor roof because of the way the building was staggered. He was there to build, almost ironically, but it's such an unfortunate case, you don't want to say ironic, but he was there to build the safety barrier on the edge of the open roof. And what happened was this. What he was standing on was part of a concrete form that had formed the actual part of the roof that he was standing on. And below him on the 3rd floor was a coworker who was stripping down those forms and literally taking a 2x4 and knocking out a metal brace that was holding it up. So a second before he took a step on that form, the coworker knocked out the brace. So then when he stepped on that piece of plywood, it all collapsed and went down to the 3rd floor, but he went down off the side of the building with some of the wood landing on his head on the 2nd floor.
Mm-hmm. And what happened as a result of that?
He sustained an extreme, severe traumatic brain injury.
Now, we're going to talk with your partner here, Andy, and tell a little bit about some of the injuries, but there's one thing that's really special that I think our audience needs to know more about, and that was he was an undocumented worker, right?
Yes, Steve.
So why is that important in the legal system in the United States?
Well, let's face it, there's a big stigma. It's very political at this point and has been for quite some time. These are people that are in this country that have a conception about them that, quite frankly, is just completely not true. I'm around these gentlemen all day, every day. They are incredibly hardworking. They will do what they need to do for them and their families. They want nothing more than to be a citizen, to pay taxes, to be part of the system. They're never looking for a handout.
Right. And the most important thing is they're entitled to the same protections as citizens, right?
Yeah. What I like to say to them is that, look, you know, just because you don't speak the language, just because you don't have a social security number, it doesn't mean that you can't have a Park Avenue lawyer. It doesn't mean that you are not able to have the same protections under the construction laws as some union member that does speak English.
As a follow-up to that, there are undocumented people who get seriously injured that are reluctant to come to lawyers because they believe that they'll be deported.
Correct.
How do you deal with that situation?
Me, along with our staff and along with Andy, we have a good rapport with these type of people because we've been representing them for quite some time. And they have a lot of fear. And so they need to be in a position where they start to feel comfortable. And they need to be able to see your track record of all the other gentlemen just like them that we represented that didn't get deported, that were made whole because they were given the compensation that they deserved for the injuries that they suffered.
Mm-hmm. I would imagine that some employers, maybe not all, might retaliate and call Department of Homeland Services, right? Do they do that? And how do you get around that?
They don't do it as often as you would think, and there's a reason for it. The onus is on the employer. An employer is supposed to ask a worker for their social security number. The employer is supposed to put that worker into their payroll system and in their workers' compensation system. There's a reason why these employers hire undocumented workers. It's because it costs them less money, A, and B, it's because they know that these gentlemen will be doing the most dangerous work for them with the least amount of safety equipment, if any. And if they won't do it, they know someone else will. So it's financially beneficial to the owner, and it's dangerous for the worker.
Let's talk about who the lawsuit was against. You filed suit against who?
We filed suit against the owner of the construction site or the land itself, as well as the general contractor which hired our client's employer.
And why are they both liable?
New York state law is unique. It's very powerful to protect construction workers, especially if the construction worker falls from a height or if something falls on top of the construction worker from a height. There's labor law section 240 subsection 1, which says that an owner or a general contractor are responsible for such an accident as a matter of law if the worker was not given proper protection. And that is an absolute statute, meaning that it doesn't matter if they had anyone on the site ever. It doesn't matter if they were there. It doesn't matter if they even had any idea of what type of equipment should have been there. I would take a deposition of some person in a suit who owned a huge piece of land that was putting up a huge condominium project, and he would sit there and you could tell that he could not understand how he could possibly be answering questions about what safety equipment there would be for some Portuguese construction worker. But the law is clear, and there's a reason for it. It's because if you can make the people at the top responsible and know that they're going to be holding the bag at the end, they have to ensure down the line that everything's done correctly.
It's commonly known as a scaffold law, isn't it?
That's correct.
Okay. Do workers know it as that law too?
That would be what a layperson would speak about with that law. That'd be maybe what you read in the newspaper.
Now, there is one exception, I'd like you to bring this up, to the liability of the contractor or the owner of the property that does not make them liable. What is that exception?
It's an exception that's called a sole proximate cause defense and or a recalcitrant worker defense. And it states this. It says, and it's fair, it should be there. It says that if the reason why this gentleman fell or something fell on them was due only to something that the worker themselves did or failed to do, meaning that the worker went out of their way to go into a dangerous area that they knew was dangerous and they shouldn't have been there, meaning that the worker was made, did have available to them proper safety equipment, a harness with a lifeline to attach to, a very good brand new A-frame ladder as opposed to some old shaky ladder. And the worker took it upon themselves to not take the precautions that were afforded to them. If that worker does that, and that is viewed as the only reason the accident happened, then liability will not attach.
Are there any other challenges, Sean, that undocumented workers have when you're trying to represent them?
What Andy and I often say to ourselves is this. The construction laws are very favorable for the worker in New York State. So what's the way that they try to defend it? They lie. They just outright lie because the construction worker is fearful, the construction worker doesn't speak the language, and the construction worker is going to do what their boss tells them. And so oftentimes the boss or someone on behalf of the boss will write out a statement in English about how this accident happened because this gentleman slipped and fell in his bathtub at his house, or something completely different that takes it away from the construction site, which takes it away from the realm of workers' compensation. And they just say to the worker, here, sign this. And what's the worker going to do? The worker signs it. He doesn't know what he was signing. That's one example. Another example is when they will speak on behalf of the worker to outside people and say the facts of the case as being incredibly different than what actually happened. And the worker themselves doesn't know it's happening. But they do this all very early on in the case because they know later they could ultimately be held responsible. And it's a very challenging aspect of the situation.
Okay. Now, Andy, you've had other cases like this, haven't you?
Yeah.
Please explain how that kind of dovetails with this case.
Like Sean said, if you don't have a defense, you have to create one. And by creating one, it's a matter of fiction. The worst example I've seen of that, and we've seen many of this, we represented a worker who was told to put a ladder on top of a baker scaffold, which you never do. It toppled over, he hit his head on the ground, and he laid unconscious. They didn't help him, they didn't pick him up. When he regained consciousness, they helped him into the basement of the building where they were constructing, and they put him on some cardboard boxes until he felt good enough to leave. He didn't leave on his own. They brought him in a car. They realized that he needed some medical attention. Instead of bringing him to an emergency room, they brought him to a private health clinic. Before going into the private health clinic, our client was advised, just tell them that you fell on the street here near the clinic and you hit your head. The client had the wherewithal to know not to lie, said he wouldn't do that. And they said, well, don't worry, we'll talk for you. You know, when you get there, you go in and you relax. They brought him in. What they told the person who took the medical history was that he fell down the stairs at home. So now documented in the records, the very first medical record was he fell at home down the stairs rather than at work off a ladder. And it presented great challenges for me at the trial. Look, I did have an easy way to challenge certain of these things. For instance, escalera means stairs, and also ladder in Spanish. So I was able to counter it that way. But ultimately, they just believed my client. But that was the worst example that I've seen of one of these contrived defenses that occurred at the scene on the date of the occurrence.
What were his injuries?
Diego sustained a high-impact injury to his skull. Right at the scene, there was a witness who looked down at Diego on the ground and saw blood coming out of his left ear, which was very telling concerning what the future course of his injuries would be because he had many left-sided injuries. The energy has to disperse somewhere. The skull is hard and it's not forgiving, so when there's an impact or force upon it, what can happen is you can sustain skull fractures. In Diego's case, he had multiple skull fractures, at least 9 of them, most of them left-sided.
And why is that important? You keep mentioning left-sided.
It's important in Diego's case because certain of the skull fractures were to the temporal bone, and the temporal bone is one of the housings to where your ear is. And where your ear is, there are structures called the internal and external auditory canal, which is responsible, one of the things responsible for balance. And in his particular case, there was a very significant, what's known as vestibulopathy. Okay, he was off balance. You and I walk down the street and we know our place within our environment. He didn't. As he would walk down the street, he would start leaning to the left. Very interesting in this particular case, defendant hired an expert to evaluate his complaints of this vestibulopathy. And the defense expert witness found that he had many different issues. They did a sophisticated test known as an electrovideonystagnogram, which can evaluate what the source is for someone's complaint of imbalance, whether it be organic in the brain, having something to do with the eyes, or ocular in the ears, or in terms of whether or not it's the stability of their lower extremities is a contributing factor. That particular witness, they were not going to call because the electrovideonystagnogram was against their interest. So I subpoenaed the witness. The doctor called me and said, well, can I come? I evaluated your client for the defense. I said, well, you can either come via the subpoena, or I can pay you for your time. You can meet with me beforehand. We can discuss the case, because an expert's opinions are not owned by any lawyer in the state of New York. And it was very compelling to put this doctor on the witness stand to say that he was hired by defense counsel, yet his findings did not support the defense.
Boy, that must have been that must have been a gift, right?
I mean, it happens, but not often. In this particular case, I discussed the multiple skull fractures. Diego had injuries to various different planes or aspects of his brain. The frontal lobe and the temporal lobe were the two most impacted in this particular case. The brain, or the lobes of the brain, all have different functions, and in this particular case, there was an across-the-board compromise in intellectual functioning, in behavior. Diego was not able to manage his inhibition response. Steve, if I would hurl an insult at you, you would sit back and think, well, I'm going to punch Andy in the nose, or I'm going to ignore it, or anywhere in between. The point is that your frontal lobe, your frontal precortex specifically, has the ability to determine how you're going to respond to this insult. In Diego's case, he lost that ability.
He couldn't control his anger.
He couldn't control his anger, and it played out incredibly at the time of trial. They actually hired an investigator to follow him, and they followed this man for a year. He was never left alone. He was always at the end of the hand of his wife, who would hold his elbow. And
just to make sure he wouldn't get in trouble.
Just to make sure he wouldn't get in trouble. And the videographer in this particular case was made, that's a term of art for private investigators when they're found out. When Diego turned around and saw a man following him with a camera, he did something very interesting, and the way it played out in court is I had the videographer on stand, and I said, and sir, Diego made you, correct? He said, yes, and that's something you don't want to happen, correct? No, that's correct. And then Diego did something that we could both agree was inappropriate and unpredictable, and he goes, yes, he did. I said, tell the jury what Diego did. He goes, well, Diego picked up a brick from a tree well and went to bash my head in. He must be crazy. I said, sir, he must be crazy, or, and he looked at me and said, or, I said, or he's brain damaged. And it went quite well.
Now, tell a little bit more about his injuries, because you supplied us with some, CT charts, MRI.
Illustrations in court are very important, so a jury can get a visual as to what the nature, degree, and extent is of the injury. In this particular case, what I did was I had a professional go through the medical records and then on schematics lay out the different injuries that were reflected in the various different head CAT scans and MRIs, which do illustrate the multiple fractures to the skull, the multiple injuries to the various planes of the brain. I mean, Steve, people talk about the frontal lobe, and a layperson thinks, well, oh, frontal lobe, that's the part in the front. Well, the frontal lobe has an anterior aspect to it, an inferior aspect to it. It has different planes. And in Diego's case, several of those planes had been injured. He ultimately developed a condition known as encephalomalacia. So when the brain is injured, it doesn't heal like other structures. Nervous tissue does not have the ability to regenerate. And so if you cut your arm, what would form there is scar tissue. Not so in the brain. Brain cells, because they lack vascularization and the ability to regenerate, what happens is those cells are lost, the brain volume shrinks down, and so the size of the brain inside of the skull is no longer normal. It has atrophied, and that's called encephalomalacia, which is what we saw in Diego's case.
It's almost like football injuries, isn't it? Same kind of thing, isn't it?
Very similar to the chronic traumatic encephalopathy that we see in football players.
Prior to going to trial, obviously you have to get all your ducks in order. And cases like this are difficult because here you have a client that really doesn't know what happened, right? And there's not a lot of people coming forward that are saying, here, let me help you out, right? So what exactly were some of those challenges? How did you overcome them?
What Andy and I like to say about our practice, and it's one of the reasons that we're successful, is that, in a way of speaking, I set them up, Andy knocks them down. Meaning I get the case prepared and ready in terms of liability, what happened and who's responsible, and then Andy analyzes the injuries and Andy takes the case to trial. In this case, like many other cases with an undocumented worker, what people would refer to as an illegal alien, the worker's paid in cash. There is no history for an economist on the stand at trial one day to go by to say, well, he paid this much in taxes these 2 years before the incident. Now we'll apply the inflation rate. He would live to such and such a time. And then this is what his economic loss is.
Yeah, that's an interesting point you bring up, because if you had worked all your life as an undocumented worker, you get paid cash all the time, actually you have no history of earnings. Because it's all based on your tax records, isn't it?
There's things that I can do. And there's things that you can do under the law. We've even had a situation where we were able to present in court envelopes that the workers were given that had the cash in them because it had the handwriting of the boss on it saying the person's name and the amount of money. That was enough. Oftentimes, employers don't realize it, but when the case ultimately does go through the workers' compensation system, because it has to, they end up filling out some forms that they send into the Workers' Compensation Board where they talk about what they paid them. And all of these things are extremely important because the economic aspect of these gentlemen being unable to not only take care of themselves, but for their families. Many of them send money home to their country where many of their families are while they're here trying to earn a living. It all is very important because it really is the only way that you can totally make whole this person that has lost so much.
There's an issue, Andy, that came up in this case, and it relates to under the New York state law called the grave injury law. What does that mean, and why is it important?
In the most abbreviated way I can state this, the grave injury law covers situations like this, workers who fall from heights that are covered by the labor laws of the state of New York, whereby if they sustain an injury that's so grave, and it's defined by the statute in many different ways, paraplegia, quadriplegia, but also relative to brain. If there was a force upon the brain that leaves the individual totally permanently disabled, what will happen in effect is if a jury gives a verdict, let's say, of $10, just for example, that $10, if it's paid by the defendants can then, if the client is gravely injured, then look to the workman's compensation carrier and get reimbursed that $10. So it's kind of a pass-through for the defendants in the case.
Okay, so why is that important in this case?
The grave injury law in Diego's case was applied in a very crazy way. Most grave injury applications are where we sue the defendants, and the defendants kind of say, well, you know, he's gravely injured. It's their responsibility to claim grave injury against the third-party employer. In this particular case, they tried to have their cake and eat it too. Defendants claimed that, well, he was gravely injured, but they were concerned that maybe the court, because it could be an issue of law, or the jury, an issue of fact on grave injury. They were also concerned, well, what if he wasn't found gravely injured? We need to minimize our damages. So I had never seen this before, but they argued that Diego was gravely injured, a permanent total disability from a force upon his brain, unable to work in any capacity, yet also that he was feigning or faking certain of his injuries. So if they found him to be totally permanently disabled, they'll give him less money because he's trying to embellish certain of his injuries. Crazy in this particular case because the man was in a coma for over 2 months.
How did you deal with that?
With a smile. I mean, jurors collectively are smarter than any single lawyer that enters into a courtroom. And even in opening statements, when I was listening to this proposed argument, I felt it was nuts. Even one of the co-defendants in his summation, after hearing this particular attorney who was putting forth this defense, when he got up in his summation, he said, listen, that may be the position of co-defendant, that's not my position. He needed to distance himself from his own co-defendant, if you will, because he knew that that argument didn't hold water at all.
Now, I understand the outcome of this case was very successful.
The ultimate jury verdict in this case was $12 million. It was $11 million for Diego, and then $1 million for his wife for her loss of services because of his injuries. So what's interesting to note is before trial, they offered $2 million, and this is after years of litigation. Just before trial, they offered $2 million, and I told the family not to take it. And their response was, "Well, you know, we're from Portugal. Diego was spent his time milking cows for a living. He can go back to do that, and with this sum of money, we're good if we go home." And one of the most challenging things for an attorney to do is to talk a client out of accepting $2 million when it's a sum of money that they would never ever think that they would have in their bank account. But I was able to do so, and it was good because the jury gave them $12 million.
And that was the final result. They ended up paying it, right?
Well, Steve, that's another great question. After the jury came in with this large verdict, soon after, they tendered or offered the $9 million that was available in coverage, and I looked at them and I said, no, thank you. Most attorneys would have gobbled up that sum of money, but at that point in time, we had already been in the appellate division for 2 years. There's 9% interest on this judgment. Every day Diego woke up, he made $3,000 of interest. So they owed us many millions more than the 9 that they were offering. And they took the position, okay, well, we'll appeal. We kept going back to the appellate division. The case ultimately settled for $10.8 million, the $9 million of insurance that was applicable, plus $1.8 million in interest that they were responsible for because of the contracts of insurance.
Yeah, that must be a very tough decision for you to advise clients not to take money because there's always the possibility they'll end up with nothing. How do you do that?
You have to have conviction to justice, to your case, and to your client, and most importantly, to the system. The system works. if the lawyers know how to work and navigate the system efficiently and properly.
One last question. This is to both of you. Sean, a lot of people call your firm. They hear of these remarkable results. How do you determine to take a case? And furthermore, let me ask this question. You both sit down and say, hey, you know, these are the pros, these are the cons, right? How does that work?
We are fortunate enough now in our practice, due to our track history, that we are able to pick and choose. And in doing so, we created an environment here that we always wanted to have, and that's this. We have a fantastic staff. We have the amount of people that we want to be here. We never want it to be big. We want to stay small. And so then when we take a case, we only take the ones that are significant in terms of a severe injury and or maybe a challenging liability aspect of the case. The type of case that we can really make a difference in this person's life as well as their family's lives because of how severely injured these individuals are. And so sometimes we'll turn down a case. Sometimes we'll think that case might be better for some other lawyer because it's something of a smaller nature. But because of that, as I said, we're able to take only the cases that we think we can really make a difference. And that's rewarding to the client. And quite frankly, it's very rewarding to us because it's the type of lawyers we always wanted to be.
Anything to add to that, Andy?
I think Sean nailed it on the head. I mean, there are many times where we'll get contacted by people who already have lawyers looking to switch to us. And the last thing that we want to do is poach cases from other lawyers in our community that we see every day. But we will take those cases if we think there's going to be a miscarriage of justice. On several of occasions, we've taken cases from other lawyers. One strikes out to mind where they asked this particular woman, or they recommended that she accept $180,000 for her brain injury. She knew that wasn't acceptable. She came to me and I litigated the case. I did what had to be done, and it was ultimately resolved for $4.5 million. So I can't think of a more drastic example of understanding traumatic brain injury and how it impacts an individual. In that case, the client knew that $180,000 wasn't fair. She didn't even need her lawyer's input, and she came to me, and we did the right thing by her.
Well, great result, and thanks for being on the show.
Thank you,
Thank
Steve.
you.
Thanks for joining us. You can get more information about our guest and the issues at insiderexclusive.com.